All right, we are recording, and I'm going to just make sure that Matt and Benjamin get presenter permissions. I'll work on that right now.
All right. My name is James Pepper. I'm the chair of the Cannabis Control Board here in Vermont. Today is Thursday, December 12th, 2024, and I call this meeting of the Act 166, Section 18 Working Group meeting to order. I just wanted to make a quick addition to the agenda. During the general discussion right before that, we'll want to hear from Sam Bellavance, who's a member of the Cannabis Retailers Association of Vermont's board. And he submitted a advertising proposal to us earlier this week, which is part of the charge of this committee, is to kind of assess the impacts of various proposals. We'll add that. We got a lot to get to today, so I'm not going to, belabor any sort of opening remarks. But I would say that we need to approve the minutes from our prior meeting of this working group, which was held on November 20th.
So moved.
I'll second.
I think
All in
so.
favor?
Aye.
Great. All right. Well, Julie, I'll really turn things over to you. You've been taking the lead on this working group.
Sure.
I should just mention, sorry,
Go ahead.
that we did, just given the kind of implications of this work, we didn't want to rush anything about the kind of final recommendations. And so we did request and were granted an extension on the submission of this report by the chairs of the recipient committees to January 15th, 2025. So we have a little bit more time to get this right. With that, I will turn things over to you.
Excellent. So, yeah, I don't have the agenda in front of me.
Sorry, yes. This is a public meeting, and so we have to follow the open meeting laws, which requires a dedicated time for public comment. I will just say that these meetings have general discussion baked in throughout. So no one who is here should feel like this is your only opportunity to comment. But if anyone has a specialized public comment that's not kind of related to the discussion, feel free to raise your virtual hand. Hear that.
Is that for working group members as well?
Anyone? Yeah, sure.
This is Graham Unix-Rufinock. I'm representing rural Vermont here in the Vermont Cannabis Equity Coalition. And I was looking at my notes from last meeting, and I had a couple just like things I wanted to offer here as a baseline reminders of some of the stuff we did last meeting, and a couple questions maybe. So one was, I just was thinking again about what Pepper, you said at the beginning of last meeting, was that the best we can do is to show the legislature how things are playing out in the real world. And so I just think, again, like that's been our emphasis too. And I mentioned last time, I think in the survey results showed us that we have extremely limited examples of conflicts. And so I think we should really focus on the exact cases where the conflicts are. Unfortunately, legislature and a number of actors supported regulatory response to that, which is going to go into effect and is going to impact people's livelihoods directly starting in January. But just a reminder of what some of those survey notes were that I think are important is that effectively 90% of towns have not received any complaints. 90% said there's no impact, and the other 10% were split between positive and negative. Only 2% of towns surveyed said there were serious impacts. It was also discussed that these setbacks will not manage smell. Kyle mentioned that, a number of people mentioned that. And there's the question of what is the real intention here? And I would add to that question, like, who are the actors pushing for this, and what's the power dynamics that exist? And this sort of brings me to a couple of questions I just wanted to bring to the League of Cities and Towns as you're a member of this group. One is, given these survey results, I'm curious, like, what type of internal process and mandate you all have for taking a position on this, and what your position is. I don't see that reflected in the survey results. And secondly, I'm wondering what role you have in the court cases happening in Essex, both related to the cannabis situation, but also related to the RAPs. Because I think what we should all know is there's another side of this is towns pushing back against agriculture, pushing back against the standards, giving the Agency of Agriculture regulatory authority, not towns, over agriculture. And the city of Essex is involved in one of those lawsuits. as well as the cannabis lawsuit. So I'm curious as to know like what the role of legal cities and towns is there and your perspective on that. And I just want to remind us that we have not visited or explored any actual conflict sites. So the question of real world understanding really needs to be applied still. And my question for the CCB would be like, in that first meeting, you went through the impact analysis you had with the surveys for the towns. And we noticed that the impact analysis for growers had been happened at like a small discussion in one virtual meeting. And I wonder if there's been any more follow-up with cultivators to more understand the impact analysis from them. And I'll stop there.
So just to answer that last question, I went back and looked. So it was the same amount of time, the municipal roundtable and the discussion about outdoor cultivation in the cultivation roundtable was the same amount of time.
So a written survey for one group?
There was a written survey for the municipalities in order to inform the conversation. Whereas with the cultivation roundtable, we knew people were going to bring information to the table and be ready to talk. So they were handled differently in order to get the conversation going. So that's the difference. But the same amount of time was spent on both groups.
Not a physical survey that went out to all towns, did not go out to all registered cultivators outdoor.
We did not survey the outdoor cultivators. No. The purpose of the survey for the municipal roundtable was to be able to develop the discussion. Whereas with our cultivators, we talk to them enough that we know that they're going to come to the table with conversation, with things to say, right? So we're trying to, for the municipal survey, it was to kick off the conversation and get people thinking about the things that we would talk about in the roundtable, whereas we know the cultivators are going to come with things to say.
I guess part of my comment, and we don't want to get lost in this, is that
Yeah.
you have now a survey and each individual town was reached out to, where for cultivators, it's whoever showed up at the meeting. And that's just to me a real marker of difference.
Sure. So to your, and to your point, so our last meeting was primarily table setting, getting the issues out, getting sort of like what we had on the table, getting feedback about that. Today's goal is to kind of continue that conversation and to get more into, to your point, Graham, like what is really happening in the world. And we've got Matt Bollinger here, who is the planning director from Williston, and we've got Ben Verardi, who is a professor at Vermont Law. And we're going to start with Matt, kind of leading off where Graham left off, about the kind of real world impacts and how land use works in municipalities, how the permitting works, and that sort of thing. So Matt, if you could kind of introduce yourself, tell us a little bit about your background, and then if you could kind of continue by talking about how these things work, like in the real world, how this is playing out in the towns.
Sure. And I assume you can hear me okay. Looks like
Yes.
my mic's on. So my name is Matt Boulanger. I'm the planning director for the town of Williston. I've worked for the town for over 16 years. I've been the planning director for the last 6. And I've worked as a land use planner in a couple of other states and regions in my career. So in my role as the planning director, I'm also the zoning administrator, which means I'm the person who, signs permits and conducts official business for the town related to, issuance of permits and enforcement of the town's zoning bylaw. I have the benefit here of having a staff, so I have a couple of deputy zoning administrators as well, other planners in the town who have some of that authority as well and who work with me. We provide staff support to our planning commission that develops policy, as well as the development review board, the select board, and a number of other advisory committees here. So I have a perspective where I have an embarrassment of riches when it comes to staff support and capacity. And that's something that's pretty different between Williston and most Vermont municipalities. We're a little more comparable to some of the bigger Chittenden County municipalities in terms of our staffing. And I think what I'd like to just sort of talk through is, in general, how we deal with land use and how we deal with land use when there are other authorities or limits to the town's authority under zoning, and draw a few parallels there. And, I can answer some more specific questions about where Williston's at and how it has chosen to address some of those things. So, we have the authority for the town to have zoning. We have some specific statutory things that we're allowed to do, things we're allowed to regulate. We also have things we're not allowed to regulate, or we have a limited ability to regulate in zoning. So there are partial exemptions from municipal zoning authority, things like schools and hospitals, and there are also, well, there's partial exemptions for state facilities, for reviewing the new state police barracks. That's different from reviewing a new commercial building, for example. There are also some things that are entirely exempt from zoning, and the biggest one is agricultural uses, right? So when somebody comes to us and they want to build a farm structure, and they say, "Hey, I'm a farmer and I want to build a farm structure," we say, "Great, go get a determination from the Department of Ag that says you're a farmer," unless I can just, blatantly tell they're a farmer, and we do have those cases too. But we have a lot of small farmers or people who are doing, enough agriculture to be considered jurisdictional under the required agricultural practices. They go get that form, and we just basically, the zoning administrator has the option to agree or disagree with that determination. We've always just agreed with them and said, "Yep, state says you're a farmer. You can go do that activity without a permit from us, and we acknowledge that you're not covered by our zoning authority." So we deal in exemptions, and we have some of those related to cannabis as well. And then in terms of experiences around growing, we are aware of one or two, I think, commercial growing operations in Williston that are, I believe, both. One I'm aware of is definitely operating. The other one, I think the person may have explored it and then decided not to do it, out in rural parts of the town. And sometimes there's been other work that's gone on those properties that maybe has required permitting, so that it gets a little sticky with that, where the neighbor might say, "Hey, what's going on out there? What are you guys regulating? What are you not regulating?" That kind of thing. But what we don't, I think, always have is quite as much clarity with cannabis and exemptions from zoning as we might with the straight agricultural uses, which have really just become very, very easy for all of us zoning administrators to handle. 99 times out of 100, the state says somebody's a farmer. What they're requesting to do is reasonable. In other words, they're not asking to, fill a wetland in order to locate a structure somewhere, something like that. They're just looking to do something that's sort of a normal farming thing. And there's a head nod from the ZA saying, "Yeah, that's great." So, I'm being really kind of generic about this because we have had pretty limited experience here in Williston. We haven't had the kind of neighbor conflicts that, for example, Charlotte was experiencing in the past couple of years. But we deal with citizens and sometimes policymakers who have some anxiety about this stuff. We deal with folks who maybe are interested in growing cannabis, who are trying to understand the predictability. Are my neighbors going to be able to drag me through a zoning enforcement ordeal? And, we're not always, I think, able to give everybody as clear answers as we wish we could, and as we are able to do for some of these other things that come in. So someone comes in and says, "I'm a school, I have a license from the State Department of Education. How is your zoning going to apply to me?" I can give somebody like that a really pretty clear answer. Whereas with growing, it's been a little more of a challenge. Other cannabis related things we've had in Williston, we have a couple of processors, testers, or manufacturers in town. The only one that generated conflict was somebody who wanted to do it in a shed in his backyard in a residential district. And it was a challenge because his neighbor, who he shared a driveway with, did not want him to do that. So that played out in our zoning and development review board appeal process. In other words, don't quote me on this because I'm doing this from memory. I think we issued a permit and the neighbor appealed it. And then it just looked like a hard enough road for the applicant that he sought out industrial space instead. So we've had a few of those things as well. We do not have a local control commission. I've raised the question with the select board at least once in the last couple of years of whether they wanted to establish one. The response I received from the select board in a really broad summary was, well, that lets us know that these things are happening, but doesn't really give us any authority over them. So why would we do that? And I sort of said, well, it lets you know they're happening, and that's a service to your citizens just to kind of know what's going on in your town and be able to respond to some of the questions you might get. And at least there's a small amount of public process there. So we don't have a local control commission. Williston has not taken or obviously approved an opt-in vote around retail. Williston did establish some local zoning identifying districts where retail cannabis could happen and under what review process it could happen. That's just kind of sitting there as a placeholder. We have no experience administering it because there's been no affirmative vote to opt in. And I would expect that if there was a vote, we would probably revisit that. That language was adopted actually prior to the settling of legislation around how opt-in was going to work at the time. So that's sort of my introduction, I guess. And my broad statement is what works really well is when I can give all people, neighbors, applicants, whomever, predictability and clarity. What standards am I going to have to meet? Am I going to be able to get a permit? If my neighbor appeals, is my permit likely to be upheld either by the DRB or the State Environmental Court or whomever's adjudicating the appeal? Those are the kind of things people want to know. And generally, I have to give people bad news all the time. Yep, there's a subdivision going in next door to you. That's what all that excavation is. Yes, they have a permit. Yes, it went through the process. Yes, they're following the rules. Yes, your neighbor is following the rules when they fire up their industrial operation, not before 6 a.m. So because we have to have a lot of hard conversations as zoners, it's really helpful when what we're communicating to people is clear. And when we're sure that we've got the accurate answer, so we're dealing with that upset neighbor or citizen or elected official who's been called by that neighbor or citizen, or applicant that maybe isn't happy about the rules they have to follow, but we're able to say, yep, that's what that is, and it's clear. So that's my pitch is always for predictability and clarity. It's what we strive for in all of our land use standards, and anything that adds that to this particular process is helpful to us municipally.
Excellent. Thank you. Can you talk a little bit about the difference? So you get all kinds of nuisance complaints. Some of them are probably related to agriculture. Some of them might be related to manufacturing, other types of manufacturing that happen in your town. Can you talk about the difference in how those nuisance complaints are handled?
Yeah.
Like if you get a nuisance complaint related to a farm, it's handled differently than if it's for, let's say, like Green Mountain Coffee Roasters, which is in your town, or a brewery that's in your town.
Sure. So I can't say I've ever actually had a farm odor or noise or anything nuisance complaint here. But the first thing is, with the exception of noise, all of the nuisance impacts are discussed in our zoning. We have a noise ordinance in Williston that deals with noise and is, enforced by the police department, as opposed to, enforcing things through the zoning enforcement process, which is another thing people should understand is what a relatively blunt and time-consuming tool zoning enforcement is. Does not result in rapid resolution of anything ever. Unless somebody is just incredibly voluntarily compliant with what you're asking them to do. So noise we deal with via ordinance, and we turf those to the police, although we do just sort of quote the noise ordinance within zoning. In zoning, we talk about glare, vibration, dust. We do talk about odor, but our bylaw has some language that says, this is really subjective. And, generally, all of those nuisance provisions, the way we deal with them in zoning is when we're dealing with a site plan approval or a permit for a new use. We're trying to figure out whether that use will create a nuisance or is likely to create a nuisance or needs to do something that will mitigate that nuisance as part of a condition of its approval. So our bylaw gives us the ability to impose conditions on land uses that are subject to it, that are meant to mitigate that stuff. And they're not always perfect, and they're not always what everybody wants. Honestly, I've taken a lot of noise complaints over the years and a handful of vibration complaints, and we never figured out where the vibration was coming from. So that was really quite mysterious. We think some industrial process was happening at a building in a certain neighborhood, and we're not really sure. It's in an industrial building, but we're not sure which one. And then it went away. But once they happen, once the nuisance is occurring, it's really difficult to capture that and handle it under zoning enforcement. It's much more about, can I impose conditions at the outset that are likely to be effective? Can I ask the applicant to present me with some evidence that shows that they won't create the kind of nuisance that our bylaw prohibits?
Great. And can you go back and talk a little bit more about the districts? Like you talked about how Williston has kind of created a district or zoning area where they would expect retail to be if there was retail cannabis in Williston. And I think in the conversation that you and I had before, I came to understand that not all retail even is zoned the same way. For example,
Correct.
Sometimes like auto stores or garages are zoned differently than other types of retail stores. Can you talk about the difference in how Williston determines where those districts will be, and how they determine why those things are different? Like, why is an auto parts store different than, or why is automobile garages or whatever different than other types of retail and other kinds of manufacturing?
Sure. So, Williston has always had a pretty big diversity of types of retail that are allowed or disallowed in different zoning districts. And we have about half a dozen districts where one kind or another of retail sale is allowed. So, for example, in our industrial district, we allow what we call like heavy and bulky retail, home furnishings, building materials, industrial supplies, et cetera, but not the kind of retail that's more likely to make a positive contribution to our attempt at a walkable downtown in Taft Corners, where the town's vision is much more mixed use, smaller scale. We have a retail district that is really the only place where we allow stuff that's in that sort of big box format. If you've been to Walmart in Williston, that's the zoning district. We have in the Taft Corners district, we have a prohibition on retail fuel sales, so gas stations. We have 2 gas stations in Williston that have been non-conforming to the zoning for over 25 years now, and we don't allow new ones there. We also don't allow retail fuel in our industrial district as a retail use, but we do allow wholesale fuel. So there's a membership-based, Champlain Oil fleet fueling facility that's allowed, but a mobile station wouldn't be, even though they look very, very similar to one another. In our historic village, we have similar sort of prohibitions on big retail, and we have some size restrictions. So when the Planning Commission a bunch of years ago had this conversation about, well, what if retail cannabis and how should zoning address that? They had a series of pretty in-depth conversations about that, and I had started the conversation with the select board, talking about generally this is a small format retail store. Place where we do that is in the middle of town. It's in Taft Corners. And so there's this wonderful Williston Observer headline that says, "Town planner says put cannabis in the middle of town." Generated a little bit of strife. Ultimately, that's not the direction the Planning Commission went. They picked 2 of our mixed use districts. One is near Exit 12, which is that Walmart district. The other is a zoning district that allows commercial and retail uses up on Route 2A, sort of near the Essex town line. So there's a Gateway North and a mixed-use commercial district. That's where the specific allowance was created for cannabis retail and permitting process. And it was prohibited in the other districts that allow retail. And to the extent I recall the conversation about picking those districts, there was a little bit of, well, these can be more in places that people are more likely to need a car to access, or need to be a sort of an independent adult versus like a young person. We want Tapped Corners to be a place where, underage kids can kind of just like walk around and hang out. And so let's have the cannabis somewhere that's a little bit removed from that. And that wasn't a unanimous opinion. It's just the one that carried the day 4 or 5 years ago when we did this. So that's what they did. And that's how it's played out. It's also not allowed up here in the village. You could have a coffee shop. You couldn't have a cannabis store.
Did they talk about other parts of the cannabis supply chain when they were talking about zoning? Did they talk about cultivation or manufacturing at all?
Yeah, just to the extent that the decision was not to focus on or attempt to regulate those things. I think part of it being the sense that the manufacturing was fine wherever manufacturing was already allowed. When those have come through our permit pipeline, they've been locating in existing industrial buildings. And permitting's been very conventional and very smooth for that. We talk a little bit about things like wastewater treatment issues and, how big's the dumpster and stuff like that. And it goes right through. And I think at the time they were looking at it, there wasn't a strong sense from the Planning Commission there was much local say at all about cultivation. So we just left it alone.
Thanks, Matt. So I'm presuming, correct me if I'm wrong, that you have residential setbacks generally, like, maybe for solar or building in a shed or something like that. Well, can you walk us through what an enforcement action might look like if you get a call from a neighbor saying this guy just built a shed, within 2 inches of my property line?
Yep.
What that process might look like?
Sure. So what we would do in a case like that, we start with a violation warning letter, which is not a formal notice of zoning violation. It's just it's a letter that says, hey, it looks like you did something that you're not supposed to. If there's a clear remedy to that violation, we'll usually express that to the person. So, you put your shed right on your property line. We're informing you that sheds actually have to meet a side yard setback. Please file a permit with us showing that you'll move the shed so that it can conform to the setback. So a warning letter. Oftentimes that's all it takes, and we just work with the owner to fix the problem. If they say no, I don't think I'm going to do anything, or I don't think you're right that I'm in violation, we would follow up with a formal notice of zoning violation. The difference is that the formal notice of zoning violation says, I am the zoning administrator under my authority under Chapter 117. I am hereby determining that you're in violation of zoning and sort of listing out the relevant bylaw section and all of that. And it gives somebody a appeal period that begins when they receive that letter for a period of 30 days. They can appeal that violation to the Development Review Board. Planning Commission in a town that doesn't have a DRB. And if they do appeal that, they have a public hearing at the Development Review Board where that zoning administrator's determination that there's been a violation is reviewed and either upheld, modified, or overturned. And then that DRB decision, once a notice of decision is sent out on that, has its own 30-day appeal period, and appeals of decisions of the Development Review Board go to the Superior Court Environmental Division, and onward if necessary. So
who represent? Who represents the municipality at those hearings?
So if we're at that DRB hearing, again, I have this wealth of staff. So I'll have one of the other planners who normally staffs DRB things, who hasn't been involved in the violation at all, write a staff report about the appeal. So, once one of us issues a violation, we kind of have a sort of a wall where we say, like, I'm not going to talk to this other staff person about that. I'm going to try to have as impartial a review as I can. And again, wealth of staff here in capacity. We have a pretty formalized staff report format we use for that. So we're writing up findings of fact and conclusions of law. We're trying to give the development review board a sense of where they might make a decision or a finding that's different from what the zoning administrator made. And then, so if I'm the ZA who issued the violation, I'm going to come to that DRB hearing. I'm not going to sit at the staff table. I'm going to sit in the audience. I'm going to be available to answer the board's questions about why I issued the violation, et cetera. And then again, I'm just going to stay out of it. If we go to environmental court, we do need to be represented by an attorney. There's a lot of folks who can be pro se at the e-court. We cannot, because we're a town. We're not a person. So we have to be represented professionally, and we are.
And the DRB, just for folks on the call who might not know, those are all folks who are appointed by your select board.
That's
right?
correct. Yep.
Yeah. And then when you have a setback question, who does the measurement? Like, who surveys to make sure that that shed or whatever it is actually in violation or isn't in the right spot?
So if we're really down to the inches, it's going to need to be a licensed surveyor. And this is actually something that has become, may become more of a challenge because of a very recent Vermont Supreme Court case about sort of the degree to which DRBs are expected to adjudicate matters like where things are and who has access. And I'm sorry, I can't name the case. We just went through it at the Vermont Development Conference a couple of weeks ago. But basically, there was a subdivision where the applicant was representing that the lots they were creating had access to a private road. DRB reviewed the subdivision under all of its criteria, assuming that that access was legal. They said, which is something very normal for us. Well, if you say that's where the property line is and you say you're going to be, 15 feet away from it, we take your representations at face value. We unless they're facially untrustworthy, we believe them and we issue a decision. That's what the DRB did in this subdivision case. It was then appealed, went up to the Supreme Court. And the Supreme Court decision basically said, no, actually, the DRB really needs to find out if this person has legal access to this road for the purposes of creating the subdivision. So, we would normally look to an issue like that and say, well, that's just going to come out in the wash, as they move forward with their project. We don't need to adjudicate that tonight at the DRB. This decision now places more of that burden back on the DRB. So let's imagine somebody is purported to be in violation of a setback, and the argument at the DRB is about where the property line is. Nobody in that room knows where that property line is, unless somebody has done a survey. And if you go to land use law clinics presented by surveyors in Vermont, as I have before, one of the sort of graybeard, very experienced surveyors in Vermont said, what I issue at the end of the day is an opinion. He said, it's a professional opinion. It's an opinion I'm licensed to create, but surveys are opinions. Determinations about where boundaries are opinions based on the best information we can get. And if you look at the methodology surveyors follow in order to locate things, they're working off of old deeds. They're working off of monuments that are hopefully in the right place, but aren't always. They're making field measurements. It's a very, very specific skill set. And the counter I can give to that is that issue of sort of the inches of where is that property line and am I really in violation or not has basically never come up for us in Williston in the time I've been here. People doing big projects get surveys done. They're generally quite reliable. people doing small stuff, we'll tell people, if I'm working with a homeowner who's getting a shed permit and they say, well, I think the line's right here and I'm gonna be exactly 10 feet off the line. I might say, if you're not sure, maybe give yourself another foot or two. If it doesn't make any difference to you, why don't you give yourself a little room so that if a survey happens later and you're in a dispute with your neighbor, you're okay. That actually generally works all right for us.
Do you know the cost to have someone come out and survey? Like a general, maybe it depends, but
Yeah, it definitely depends. But you're likely in the thousands of dollars to have a survey done.
thank you.
Matt, I don't expect you to know how all the kind of farm exemptions that have been granted to outdoor cannabis are going to play out. But when it comes to this specific setback language that was just passed in July, is there, if you don't have to give me an answer today, but if there's any clarity you need about what that language means or how to apply it, that would be helpful for this report. Just because we did a municipal survey and there was some confusion about some of the questions around what the language actually means. I mean, one thing that strikes me, and again, we're in the question of probably inches, but are you measuring the setback obviously from the property line, but are you going to like the closest leaf of the plant, or are you going to the stalk of the plant? Just like, again, like, and those things will change as the plant grows. So, I think that's just one example of maybe some clarity that you would like to see from either the legislation or the board, our opinion of it at least. But if you just have any thoughts about the clarity of the language or how it could be better, how it could be more easily administrated, please let us know.
Yeah.
Sure, I'm happy to take a look at that. And the ones that come up for us are about buildings, and it'll typically be, is it the foundation? Is there a reasonable overhang that a structure can have into a setback? What if I build a rack on the back of my shed to put my canoe on, and that goes into the setback? It's usually these kind of like overhang questions that we get. If you're down to where the stalk hits the ground versus where the leaf hangs, yeah, if people need clarity around that, I think it can be drafted in a way that doesn't create more problems than it solves. But there is this other thing, and the former Burlington city planner said to me once, sometimes simple is complicated. And I'm also happy to look at any added language you want and tell you whether I think it makes it easier or harder. But it can really be a balancing act, and we're lucky that most of the time we come down to kind of a reasonableness standard, and it works okay. But I hear you.
Samantha.
Thank you. Can you talk about the process if a property owner wants to convert the use of a property? So if they buy residential and want to convert to commercial, or if they buy commercial and want to convert to agricultural, and when they want to convert to agricultural, when that was not the prior use, does the municipality have a role in that? And what if any restrictions would there be, or like the process to do that? So like
Sure.
if I bought like a residential property and wanted to use it for a poultry farm, how would I do that?
So the first part is just any change of use. We have some definitions in our zoning about how much things have to change before we consider it a change of use requiring a permit, and then whether that permit can be issued, administratively by me without any other review from the development review board, or we have a few, like establishing cannabis retail goes to the DRB in our current regime, even if it's a existing building. So then to your more specific example, which would be someone buys a residential property and they want to be a farmer. generally there, somebody is changing the use or adding a use to the property, but that use is going to be a required agricultural practice that our zoning doesn't have jurisdiction over. So that's a pretty special case for us. It does happen. Somebody says, you know, can I buy this house on 5 acres and add a poultry farm to it? If the state of Vermont says that that's a required agricultural practice subject to their jurisdiction and therefore not mine, sure, you can do that, and it would not require a permit from the town of Williston to do that.
So the state rules on jurisdiction for conversion to agricultural use.
Yeah, so they rule as to whether the proposed use is an agricultural practice that's subject to what they call the RAPs, the required agricultural practices. It's mostly about water quality, but it has this added effect of taking that use out of the jurisdiction of local zoning. My understanding from many years ago from a former town attorney of ours was that the zoning administrator, if they were to disagree with that determination, does have the opportunity to say no. But that is very, very rare. All of the ones I've ever seen where somebody went and got that determination, it was, you know, very clear they had met the statutory thresholds to be considered a farmer. And you know, this was a great piece of state law. There used to be a whole long list of how many of what kind of animal you had to have in order to have
Yeah.
enough to be a farmer.
Yeah.
You could almost sing it to the tune of Partridge in a Pear Tree, which some of us tried once at a planning conference. But it's been very nice to have that determination go over to somebody else and just be handed that, so I don't have to ask somebody how many chickens they're going to have. I
Yeah.
just get a letter with a nice state seal on it that says, we think this person's a farmer. We think the thing they want to do is an agricultural practice. And I can just say, yep, I agree, stick that in the file, put it on record, and zoning stays out of it.
And I also want to hear more about the relationship between nuisance law and the permitting process at the front end, because like a nuisance complaint that I'm aware of that happens a lot in Vermont, especially when someone is building something for commercial or retail use, is like traffic, right? Like neighbors will say, oh, this new brewery is going to have people driving in and out of the neighborhood at all hours of the day and night, and that is a nuisance. But if the zoning process says they are allowed to have a parking lot, they are allowed to have traffic in and out, they have, like, this is an allowed use of this property in this commercial district, then that would make the nuisance complaint about vehicles like mute, right?
Sure. So I wouldn't view added traffic on a road as a nuisance impact, although I'm sure someone who lives on a road where something busy shows up might, you know, experience it that way. We have in our zoning, and most communities in their zoning have other rules and thresholds that are very specific to traffic generation. So,
Yeah.
you know, our DRB can require a traffic study. We're primarily looking at whether the road will be taken to an unsafe level of traffic. So, you know, busy and maybe a little slower isn't a problem, but unsafe is. Or will the development cause a nearby intersection to fail to function properly or to function below a level that the town can accept? But you know, generally on matters related to things like traffic, hopefully the town's approach to traffic starts in its comprehensive plan with, you know, how are we dealing with our transportation infrastructure? What have we decided is an acceptable level of congestion? What is our very long-term plan to, you know, mitigate areas that are problematic? Are we asking new development to pay its fair share of the needed improvements through an impact fee? We do in Williston. We charge quite a lot for that fee. Do we have a good capital plan to put that to work to improve intersections or roads that are becoming congested due to new development? So that approach is going to vary widely across, different municipalities, but traffic is kind of it's a specific enough impact that comes with new development that we have whole chapters of zoning and sections of our staff reports that are related to it. So that one's a little different. But just like making the adjacent road busier than it used to be, would not rise in the eyes of our zoning to the level of nuisance.
Yeah, I guess, okay, so traffic was a bad example for what I'm trying to hear more about. I guess, my perspective would be one that, similar to Megan Tuttle, former planning director of Burlington, who I learned a lot from, that more prescriptive zoning is helpful in that it limits the right of appeal and process of appeal, and it provides clarity to the governing bodies, whether that be the zoning administrator, the DRB, or even if something gets to the court system. So the community has a comprehensive democratic public planning process that prescribes specifically what may and may not happen in its zoning district. And then that allows the builder, the developer, the property owner, or the operating business to perform their business legally on that property without being subject to, frankly, nuisance appeals in the act of them doing business. And so I think when we talk about nuisance law or the ability of a municipality to zone, that can sound scary and you're limiting, anybody could call anything a nuisance. But I want to understand better how the relationship between the prescription of a zoning district affects the ability of someone to make a nuisance claim down the line, if that makes sense. So if the zoning says this is a part of the municipality where you are allowed to have outdoor performances and live music and whatever, and then someone opens a brewery and then 4 years down the road they get an outdoor entertainment permit, but a neighbor says no, this is a nuisance, I don't want to hear Billy Joel cover bands in my neighborhood. What then, but if the zoning says you can have outdoor entertainment here, right? I guess that's what I'm trying to understand, and I generally don't really understand is how someone can get a zoning permit for an allowed use, and then what happens with a nuisance complaint later.
So if somebody had a permit for something and in conducting that permitted activity, there was then a complaint, it's too loud or what have you. Let's say that came down the road. In my role, I'd be looking at what were the limits of the permit, which I'm going to assume was issued in compliance with the zoning, and is the person or the party in excess of that permit. It can be tough to regulate that stuff. I mean, we have things about, in our village where we have a historic village, but we're trying to have mixed use, and there's, small restaurants and bed and breakfasts. We have some rules about when can the Cisco truck come with the backup alarm on to try to, deal with the fact that everybody's pretty close to each other here. And if I get that complaint, I can go in and say, oh, well, when we permitted this restaurant, there was a condition established about the timing of big trucks coming to the site to mitigate noise. Are you or are you not over that line? But the truth is, in the zoning world, anybody can sort of allege a zoning violation. And even if the zoning administrator says, no, I don't think it is, they can take that complaint and sort of run it through the entire process.
Yeah.
There's stuff out there where somebody said, hey, my neighbor's in violation of zoning, and the ZA says, no, I don't think they are. And, they still end up in environmental court. I can't stop that from happening. I can disagree. I can say, I'm determining there's not a violation, and then we can go hear that appeal at the DRB and beyond. But there is no sort of like perfect protection from that for someone who has a permit. All things have appealability. All things that I do with that zoning administrator hat on, whether they're issuing a permit, a denial, or even choosing not to act on something, may be able to be appealed and litigated. That's just part of where we live.
But Matt, what I'm gathering, though, it's important for this conversation, is that zoning violation and enforcement track is a totally separate track than a nuisance track suit between, disputing neighbors.
Sure.
And do you have any involvement in the nuisance part of things other than you guys set the kind of allowable uses or whatever else?
Right. So I should be clear. We're talking about something that violates either our zoning or a nuisance ordinance in town, not just one neighbor with a civil action against another,
right,
who says, hey, you're making too much noise. And, a private civil action between two neighbors, they may point to the zoning or the permit as, either a defense or an accusation. But we're not involved in that at all. And,
right.
Anybody can sue anybody for anything they want to, whether they'll prevail or not is another question.
Barking dogs is a good example of that.
Yeah.
Sure.
Right.
I think
zoning
we
has
got
nothing
one
to do with dogs bark, but people sue.
Yeah. I think we got one last question for you, Matt, coming from in the room, and then we gotta just keep going through the agenda.
Yeah, thank Mac. This is Graham. It's been really helpful, but I wonder if we've this current law that was just passed last year that's going to come into effect in January, affecting cultivators in the cultivation district. And correct me if I'm wrong, but I think it requires maximum 10 feet in unzoned areas, maximum 25, default 10 in unzoned areas, setbacks for outdoor cannabis production, default 25 feet maximum in cultivation districts, and default 50 feet maximum outside of cultivation districts. Or is that minimum? Maximum?
Those are maximum.
Those are maximums. So I wonder if you could compare those, Matt, to ag setbacks into various different types of setbacks you have for different uses in your town. And maybe as well, given what you said, like you're a very unique person coming before us representing towns in Vermont, right? Like town I live in, Marshfield, the DRB is not appointed. It's, people volunteer. It's all volunteer run. And this is the majority of towns. Essex, Charlotte, Williston have different histories of land use and different stuff. So maybe there's also a little bit of like, if you're able, I'm recognizing you're not the League of Cities and Towns, maybe they can give better perspective, but like, how does that compare across towns in Vermont for different uses?
Sure. So I'll just sort of speak for Williston. We have setbacks for what we call development, and that generally means for some kind of a structure, but might include something like a stormwater pond or a parking lot or something you might not think of as a building per se. In our agricultural zoning district, our most rural zoning district, it's 15 feet side and rear and 50 feet from the road, 25 feet, I think, from a private road. And in our other districts, those setbacks are smaller. In our most suburban residential district, those setbacks are 10 feet side and rear and 25 feet from the road. And then in most of our mixed-use commercial or industrial districts, we have a flexible setback standard where more or less the more landscaping you're willing to put into the setback area, the smaller that setback can be. The smallest being if you employ a berm and a hedge, it gets down to like just a little under 7 feet, something like that. So they're very context sensitive. And I should mention in Tap Corners, we actually have some zero setbacks where, two buildings can touch on their side yard. But that's like sort of our general spectrum of setbacks. they're usually not 25. They're not anywhere in Williston 25 or 50 feet from a side yard. They're going to be 10 or 15.
Great. Matt, thank you so much. Really helpful.
Thanks for having me.
context. I'm sure there's more questions, but we'll probably just have to follow up afterwards if you're up for it.
Yeah, I'm happy to follow up. And if you want to send me any text or, how would this work for you kind of questions, I'm happy to do that.
That's great.
Thank
Really
you.
appreciate
Sure.
it.
Thank you.
Thanks for having me.
Okay, Ben, you're up. I wonder if you could sort of start the same way, just kind of introduce yourself and give us your
Sure.
background. And then I think you have slides to share, right?
I do, if that works for everybody. Although please do feel free to jump in with questions. I don't know this audience that well, so was taking some guesses about what you knew and what you didn't. But I think I got that coming up. And while that's loading, I'll note one other possible interesting point of comparison on the setback thing. High THC cannabis, of course, is not eligible for organic certification, but we do see rules there around buffer zones, and there's not a universal standard, but those are often in the 25 to 30 foot range, and typically have to do with avoiding I guess you'd say cross-contamination from banned pesticides and the like. Anyway, hi everyone. My name is Ben Barati. I am an associate professor at Vermont Law and Graduate School, where I teach. I've taught cannabis law there for the last 3 years. I also teach business and general agricultural law. And before that, I was a cannabis law practitioner. I was based in Oregon, but worked nationally in consultation with licensed attorneys in other jurisdictions. And before that, not on the slide, was working primarily in other vice-oriented areas. So did substantial amount of work on working with electronic cigarette clients, and some in alcohol and otherwise. I am required by dint of my position to start off with a couple of disclaimers. Wouldn't be a law professor without it. I am not here on behalf of Vermont Law Graduate School. I am here all by myself, and my opinions are mine alone. Also, I'm not licensed to practice in Vermont, which I mentioned for two reasons. One, because there's a public record, and you never know if somebody might watch this later and want to take some legal advice from it. Please don't. Not least because unlike everybody else here, I don't interact with this material in as much of a hands-on context. Mr. Boulanger is, of course, working directly on zoning issues. Our commissioners are interacting directly with stakeholders. I tend to look at this stuff more in terms of the scholarship that has been conducted, research that I do on my own on sort of a national scale. But while I am going to talk a fair bit about Vermont law, this is really my understanding from the reading that I've done, and is not only not binding, but please do interrupt me or correct me if I say anything that's just wrong as to my my understanding. And please feel free to jump in throughout. So a little bit of agenda. I won't take too much time with this. Bottom line, I do want to talk a bit more generally about land use and the current state of the law, and then some considerations I think are important in an Act 166 context. And then I'll tell you right now, the conclusion that you're going to hear from me is that I feel generally high THC cannabis should be regulated like hemp, that is to say, like all other agriculture. And I believe, and this might help clarify some of the questions that were recently asked, that our extant nuisance provisions do a great job of addressing the sort of individual concerns that might arise, while an aggressive outdoor siting law, I think, could present some issues. So starting off from a real general sense, really the question in the back of everyone's minds, I think, should be whether we want to regulate cannabis and hemp differently. And for purposes of this presentation, when I say cannabis, I'm talking specifically about high THC cannabis, as opposed to what the federal government calls industrial hemp. I imagine most of you have some background on that distinction. As a matter of law, cultivation of less intoxicating hemp plants is considered agriculture, while the more intoxicating cannabis is considered a vice. And that's pretty relevant from a land use perspective. Land use and zoning really got started in the early 1900s, and I won't give you the whole history, but really it was originally intended to mitigate some of the harms of unchecked urbanization. And what happened was very quickly, folks discovered that zoning rules could be applied to incentivize or punish certain types of social behavior, or in many circumstances be applied to further marginalize folks who are economically disadvantaged or from minority groups or whatever. It took about 1 year from when New York first passed a comprehensive zoning statute to when they had to amend it to say things like, hey, you know, no Irish probably isn't a valid basis for zoning. And we see echoes of that still when we're regulating, for example, high density residential areas. We have to balance what that means, and I'm sure many of you know this, between our desire to maintain a particular character with a need for affordable housing. And this comes really into focus in this topic because historically our agricultural land use restrictions have been based around preserving farms, preserving farmland, and protecting against suburbanization and sprawl. And so we typically see zoning regs that say things like you can only engage in agricultural activity in this area, or primarily such that the major use of that land remains in agricultural production. By comparison, when we look at vice regulation, it's almost always the opposite. We are looking to reduce the presence or visibility or just existence of industries with low social status. And there are two sort of major strategies that tend to get deployed. This idea of packing, when you say all the cannabis retailers in this jurisdiction will have to exist within this neighborhood, and similar, or cracking, which is exactly the opposite. No more than one dispensary per neighborhood or per however many thousands of residents or whatever, which tends to disperse it and reduce competition. Both of these approaches have some challenges. When we look at packing, there are substantial issues that can come about in terms of what that means for those host communities. I do wonder, I don't have data on this, whether in a cannabis specific context, there might be some increased risk of pollen drift and some of the trespass issues that come up there. And conversely, when we see these limitations on density, the way most jurisdictions have chosen to do that in the cannabis space is through license limitation. We're just not going to issue licenses to operate, and Vermont has substantially resisted that. So to one of the questions that was asked, it's important to understand that land use and zoning are distinct from nuisance, but very much seeking to get at similar issues and really derive from a lot of the same rationale. When we talk about nuisance, we have private nuisance suits. A specific neighbor is impacted by the glare from a window. A specific neighbor is denied some particular benefit of their property by dint of the action of another, as opposed to public nuisance, which relates to the rights, including sort of the right to move through the world peacefully, that is held by the public, and so those can come up, typically enforced by government actors. There can be class actions, but it's quite limited. And what land use and zoning principles are kind of doing is saying, okay, well, we're going to prospectively just decide that some stuff is a public nuisance, or at least it's a public nuisance when deployed in this particular community or in this particular neighborhood. And so it ends up being kind of a proxy, declaring up front that these activities are going to adversely impact the public, such that we are going to restrict them in advance. So Act 166, excuse me, looks like it's kind of encouraging a specific type of citing approach. You know, when we look at incentive-based citing, we're saying, okay, well, we're going to provide some specific benefit for inducing business owners to come into areas of low employment, come into areas where buildings need rehabilitation. Sometimes often we see an improved economic impact by that. And we see versions of this all over the place. But usually when we're doing that, what we're doing is bringing in new businesses and bringing in new dollars, often from out of state, and often kind of trying to compete with out of state stakeholders in terms of reinvesting in our communities. Conversely, when we look at restrictive siting, these are those ideas of there will be no more than so many dispensaries in a neighborhood, or they can't exist within the city at all. What we find is that often the folks who are hardest hit by that tend to be urban entrepreneurs, tend to be low-income entrepreneurs. These are folks who may not have the resources to just pick up and move. And similarly, and this is something that at my institution, a lot of folks in the environmental justice community look at. We see that a lot of times the designated permissible areas that remain as low-income communities are adversely impacted by the concentration of any environmental or economic harms or whatever. So in an agricultural context, we do see, and Mr. Boulanger mentioned this, quite a number of agricultural exemptions. Zoning, it's not on the slide, but we do see that in most jurisdictions, agricultural activity enjoys exemption from most municipal regulation, at least as it relates to those required agricultural practices. We also see the differentiation in Act 250 and now through Act 166 in the cannabis space between farming and other development. And in the nuisance context, and do be mindful, nuisance and zoning are distinct, but in the nuisance context, we have a rebuttable presumption that agricultural activity is not nuisance where these four factors are met. Essentially, you're in comportment with whatever law governs your industry, you're engaging in good agricultural practices, and there are definitions for that. And importantly, that the activity has been established prior to surrounding non-agricultural activity. And this is part of the doctrine of nuisance more broadly. If I understood the question earlier about, well, what happens if a location has a sound permit and then there are allowed concerts there, some of the question becomes, well, who takes issue with it? If, I happen to live here in Randolph. I'm like just a few houses down from Forest Hill, which has a big concert series. I knew that going in. Because I knew that going in, the doctrine says I'm coming to the nuisance. This is something I was aware of. And so we typically broaden that in the agricultural context and say, if the farm activity was taking place before the non-farm activity, that is going to enjoy that presumption. And also we look to what extent has that activity changed over time. We'll talk more about the right to farm law and how it relates in a nuisance context, but do understand that just going in, if we did nothing, if y'all just went home and missed all the rest of your meetings, and the recommendation was let's do nothing, this nuisance interpretation would still apply. Cannabis cultivators, hemp cultivators, whomever, aren't going to get any more of an exemption than the current one, which does look to not only whether or not you're in comportment with existing law and regulation, but also sort of who is there first and what the expectations are. So I think you all know most of this, but it's really worth repeating because this is, in my mind, very much the issue. We have this bifurcated system where you have the same plant, and if it contains less than 0.3% Delta-9 THC, we consider it at a federal and a state level agriculture. So our operators are eligible for federally backed loans. They can get organic certification, bankruptcy protection, all that stuff regulated by the Agency of Agriculture, Food and Markets. As soon as we cross over 0.3%, now it's cannabis or federally marijuana, and all those federal protections go away. So the protections that remain are the specific carve-outs that we have and the protections and limitations that are put in place by the control board. So at present, if you have a CBD hemp producer who's growing plants that have a strong odor and is bringing them by truck to to the next stage in processing or distribution or whatever, this is going to be considered agriculture and it's going to receive the full suite of exemptions. If those plants look and smell identical and are grown in the same volume but have more than 0.3% THC, we then have to look much more closely at whether a specific exemption applies. So in Vermont, we do see some harmonization, particularly following implementation of Act 166. I mentioned dairy on the slide because it's the stinkiest industry I'm aware of, and one of the noisiest too. But we see dairy, hemp, and cannabis producers are all going to be considered farming for Act 250.
I'm
They're going to
sorry.
get.
I'm sorry.
Oh, sure, we got a
but
question. Wonderful.
There's really bad feedback from in the room.
Oh.
And could you
Yeah,
mute
it's the conference room again.
temporarily?
Yeah, something just
Yeah.
happened where there we go.
Yeah, thank you so much. Sorry, I couldn't understand. Thank you.
Sure. Any other questions? This is good, as good a point as any to take a break, see if there are other questions so far.
I've got one of those subjective questions for you based upon your own personal knowledge, Ben.
Uh-oh.
Would a hemp farm be, what's the difference in odor between a hemp farm and a cannabis farm that's growing the equivalent amount of plants?
Yeah.
Is it just the intensity and duration of that odor, like during the part where it's flowering beyond the 0.3%?
That's a great question. Depending on the strains that are grown, there may be no difference. So hemp can be, I'm hearing that echo too now. I don't know if y'all are getting that. So when we grow hemp, we can be growing it for fiber. Most of the market right now is in CBD hemp, and just like high THC hemp, it's going to be strain dependent. And so we absolutely see, and increasingly the market for sort of our artisanal flower is starting to resemble the high THC market, where these plants are still being grown for their terpenoid content. All of the odor of the cannabis plant isn't within THC or CBD. It's really within its aromatics, and so that absolutely can be grown identically. It's really just going to be about market demand. Did that answer the question?
It did. Yes.
Yeah. So we do see that for the most part, we have increased agricultural exemptions for both hemp and cannabis, including that rebuttable presumption of non-nuisance, as well as the ability of other state entities to enforce nuisance laws as they apply. So in addition to the state generally, and we could see, we could see municipal police involved in whatever local definitions may exist for nuisance. We also see that many municipalities have a public health officer who can declare something a nuisance as a matter of health law. And the Vermont Agency of Natural Resources is administering essentially administering provisions of the Federal Clean Air Act, which also have components related to odor in particular, and there's some specific standards there that would still apply. The interaction between that enforcement and the nuisance exemption hasn't been substantially explored. You know, I took a look, and there have been a total of 9 published cases on this issue that I was able to find ever, and the closest I got to some determination on odor specifically was a case that said, essentially, odor could be nuisance. It's not trespass in this particular case, and that's as much as we're going to talk about it today. Thank you all for coming, said the Vermont Supreme Court. So still some uncertainty there, but there are these enforcement channels that currently exist. Diversified
That was
farms.
nine cases in Vermont.
Yeah, correct.
Okay.
And I will, by the way, send along a document to the board with their permission, summarizing all of this and providing some additional citations and references. So we do see that diversified farms, those that are producing multiple crops or multiple federally legal crops and cannabis, are going to be exempt from many of those municipal land use restrictions. That gets a little bit tricky in practice, and I'd frankly defer to the board and Mr. Boulanger on what happens when you have a farm that is functionally a single operation, but has segregated out its cannabis operations into a separate LLC, either to maintain comportment with other federal regulation or for liability limitation or whatever. The setback provision, it sounds like you all have talked about quite a bit. That's additional, and of course, the control board can bring in new restrictions relative to operations. I'm not going to say entirely. Oh boy, what's the diplomatic way to say that I think you guys can do whatever you want, but I think you can't. I think you wouldn't agree. Sorry, I had notice of another hand come up and then it went away. Something else. Okie doke. So, what's supposed to be our lodestar in all of this? In my thinking, and I want to make clear this is my opinion, it's really the specific mandate that derives from our cannabis statute. This is 7 VSA 904A, which says, is the intent of the General Assembly, it's the point of the whole thing, to move as much of the illegal cannabis market as possible into the regulated market, and to encourage participation in the regulated cannabis market by small local farmers. And I know how much work the control board has done in seeking to achieve the right balance there. I think we all know that the vast majority of cannabis producers in Vermont and really nationwide and farmers are both small and local. And nationwide, cannabis production and traditional farming are both pretty unprofitable. The numbers from the USDA say the average income on a farm from that's derived from farming activity is about negative $5,000. I don't have the same data for cannabis cultivators, but I can tell you that what the survey suggests is that about 70% of cannabis industry participants, including cultivators, wholesalers, processors, dispensaries, about 70% say that they're currently unprofitable, in part due to IRS 280E and tax issues, and also in part because of compliance costs. So I would personally encourage you all in thinking about this, when in doubt, to kind of go back to the question of how is this going to impact small, poor farmers, whether they're currently growing cannabis or other crops. Some other considerations you should be aware of, to the extent that outdoor siting is going to require or propose that some folks relocate to other properties. Be aware that agricultural lending and subsidies and the like are completely unavailable to cannabis market participants. Also in Vermont, conserved land can't be used for cannabis cultivation. That's a mix of conservation entities in part getting federal assistance and sometimes relative to their nonprofit status. We also can't cultivate on most mortgage property because most mortgages are federally backed. So in order to find an appropriate outdoor cultivation facility, often it has to be one where the property is owned outright. And that can present substantial additional expense. It's rarer. You should also be aware that the Farm Bill is very likely to redefine hemp, and I don't know how closely you all have been following this. At present, that 0.3% issue cap is one that not a lot of folks are happy with. We don't know exactly what will happen with this. The sort of most credible suggestions are that there's a good chance that the cap is going to be lifted to 1%, but there's going to be new language added that essentially says it depends what you're growing the plant for, whether your intent is to grow it for drug consumption, including CBD and other cannabinoids, or whether it's specifically for hemp fiber or birdseed and the like. Federal rescheduling, up until a couple months ago, I would have told you all it was a done deal, including after President Trump made his first pick for Attorney General. A little bit less clear what's going to happen with that now. We have a hearing upcoming in January, but all indications are that rescheduling is likely to happen at some point in the next few years. And that, of course, is going to trigger some consideration here in this body about whether cultivation regulation should be handed over to the Agency of Agriculture, Food and Markets, and presumably some conversation about what that means for rules like this one. Also, and I suspect many of you are aware of this, prices are going down all over the place for a number of reasons, mostly because it turns out it's pretty easy to grow pot, and there is some expectation that as competition increases and also some rules may relax relative to interstate commerce, we're going to see additional downward price pressure. So these entities that are already struggling to survive, particularly the smaller operators, are themselves in a sort of race to the bottom market. So that's kind of the setup. I know one of the things y'all are tasked with considering is the current impact of cannabis cultivation on municipalities. I'm not a great person to speak to that because I don't spend a lot of time looking at that analysis from a Vermont perspective. What I can tell you is, generally speaking, the impacts are largely positive. We see increased tax revenue in those communities, very slightly increased employment, but it's not a lot. You don't need a lot of people to run an operation like this. Property value impact data is really inconsistent. Essentially, National Association of Realtors did a survey, and sort of equal numbers. Well, the majority of people said cannabis cultivation had no impact on property value, with sort of the other sides of that curve being values were slightly reduced and values were slightly increased. We do see statewide, on average, crime tends to be reduced in jurisdictions that have legalized and allow cultivation. Some additional property crime specific to the market participants themselves. So farms and dispensaries being targeted and robbed, and the belief generally is that largely relates to the fact that federal prohibition makes it still a primarily cash-based industry. And I know that's something that the board has looked at quite a bit. We've also seen, and there's a lot of good data on this, that outdoor cultivation is substantially better for the planet and better for energy bills, better for infrastructure. Even when you have light supplementation and the like, there's not even a question. Indoor cultivation is dramatically harder on the environment. It also offers some benefits from a social equity perspective. It's easier to get into the market. It's easier to maintain an operation, and it's easier to maintain compliance. To give you a couple of data points in terms of outdoor versus indoor. At one point, Colorado, where pretty much all cultivation is indoor due to the climate, hit 14% of energy usage statewide was due to indoor cannabis cultivation. And there were a number of mitigating steps that were taken, largely some incentives and then some requirements relating to renewable energy and the like. And that energy concern is also, as I understand it, part of why this board adopted a hybrid license type in consultation with Efficiency Vermont. Essentially, what we see is that facilitating outdoor cultivation in all of its forms has better outcomes for market participants and for the state as a whole. So, what are likely impacts? This is why I have kind of what might be a little bit of a strange opinion, given that the statute already says, well, we're going to go ahead and allow municipalities to do some decision making on this, at least in an incentive based context. I'm not sure personally that that's the best fit for Vermont. When we say we're going to provide tax benefits or some other incentive for qualifying properties, what happens is that the cost of those properties rises substantially. Now we're talking about the properties that are wholly owned, that are in the right zoning area, that also have conditions that are suitable for cultivation. Those tend to skyrocket, and then there's some upward price pressure across the agricultural landscape as a result, and commensurate reduction in inventory. Little bit of speculative increased costs in transportation. Mostly you got to bring your product somewhere else and traveling further distances, additional safety concerns in order with that, that come along with that. And we also do have good data that says that when we change our siting restrictions, what we see is more folks who are transitioning from buying property to leasing it, which again substantially increases overhead, which is particularly challenging for folks who are more cost sensitive to begin with, our smaller cultivators. So the end result is that the folks who tend to benefit most from these incentives are wealthier operators, at least to the extent that the increased land prices aren't going to offset the incentive savings. And so in a state where we're seeing rising property prices across the board, there is some possibility it could accelerate. And conversely, we don't really have the apparatus to replace displaced cannabis cultivators in urban zones with other industry types. It's not like folks are necessarily trying to open basil farms in downtown Montpelier or whatever. That the numbers just don't support it. And my big concern here is that we've seen examples where these kinds of structures can actually attract the sort of corporatization that Vermont as a whole has been trying to, if not resist, at least not incentivize. In Canada, for example, we have a highly permissive land use scheme when it comes to cannabis cultivation, but the biggest catch on it is that the full site needs to be built out prior to license approval. And so what happened was you saw a number of small operators who quickly entered the market, and then you had the billion-dollar MSOs that spent that same amount of time bringing in an investment to create these enormous cultivation facilities, and it kind of militated towards total corporatization of the market. There's now, I don't have the numbers in front of me, but it's something like 8 companies control like 90% of the Canadian market. Conversely, if we look at restrictive siting, if we say you can only cultivate cannabis in these specific locations, we've seen that in action in a lot of states. Now the prices for those appropriate properties fully skyrocket. The data also says the other outcome is you see a big jump in demand for indoor cultivation facilities as an alternative, and that makes sense. Mr. Boulanger mentioned this about the zoning conflict in Williston, where the neighbor appealed and the cultivator said, I'm just going to go into an industrial space, right? And that's great if you want to temporarily pump those out-of-state investment dollars into warehouses, but we don't necessarily capture substantial long-term benefit from it. These are still not high employment ventures. Our major beneficial interest owners are often outside investors outside the state, not necessarily paying tax here on whatever dividends they receive. And so the end result is urban agriculture plummets. Our diversified farms can't afford to move. They're going to discontinue cultivation. And realistically, there's also a non-zero number of cultivators in those circumstances who are just going to return to the illicit market. We've seen that in California, for example. The competition from the illicit market has jumped substantially as compliance costs and land use regulations have just made it not only difficult to run a profitable operation, but really sometimes to operate a business that's economically viable at all. So, I'm going to take a pause here because I have a couple of slides discussing what municipal authorization might look like, but do want to see if we're feeling comfortable in terms of background understanding and the citing specific concerns.
No, I mean, this is really informative. I mean, one question that I have that was debated in the legislature, and I don't think we got a definitive answer. And, maybe we just have to wait to see how these things play out before there is a definitive answer from a court here in Vermont. There is some question about setbacks that are going into effect in January and their effect on incumbent licensees that got their license when the setback was not in effect and are now kind of zoned out of existence.
Yeah.
So the kind of retroactive, I guess not retroactive, but the kind of interplay between new requirements on a cultivator that may have the effect of them not being able to operate at all.
Yeah, for sure. So and I haven't looked specifically at the legislative history on this. What I can tell you is that the typically analysis here arises under what we call the law of takings, regulatory takings. And so the question often comes up, to what extent can a government restriction impinge on the commercial activity within a given property? And the answer is quite a lot. The general law on this, jurisprudence on this, says essentially we're only going to consider this a taking if the property is left with no possible commercial use. And so if there's some other commercial application that could be implicated for the property as a whole, perhaps, or within that setback space, perhaps, what we see is typically when the setback has a legitimate purpose that's cognizable under the law, there's a great deal of latitude in terms of imposing those restrictions. That, in my mind, is a real problem for existing operators, and it's one we see that's played out in other contexts, in other agricultural contexts, fairly often. It's very hard to challenge these setback as taking, and so sometimes what we see are circumstances where regulators or lawmakers will kind of split the difference and say, well, the setback provision is only going to apply to new licensees, or it's only going to apply to folks who move properties or the like. You know, I understand the rationale of that. The problem in my mind is either you have a reason for the setback or you don't. And if it's an important enough reason to be implementing the law, presumably there's a strong interest in preserving it, particularly when in an agricultural context, we have so much policy that says what we really want to do is set folks up for long-term success. And that means long-term exemptions.
Sorry to put you on the spot with some legal advice, which you said that you're not granting. But I will say that your analysis just there about takings and the interplay with kind of new restrictions is exactly in line with what Legislative Counsel said during the committee process.
Well, that's a terrific relief. Glad to hear it. Go
on. We have a question in the room.
Yeah, this is Graham from Earl Vermont, and thank you, Ben. I would love for you to come and testify with our coalition, the Vermont Cannabis Equity Coalition, you know, when we go to legislature, because we're going to be asking for them to revoke this. And I think your testimony has been very powerful. One thing I just wanted to add to you, your slide around ag aspects of agriculture or things that qualify land as non-permissible for cannabis production. Mm-hmm. I would put NRCS agreements and farm agreements with federal contracts. We've met a number of farms who want to enjoy, but you know, that should be added there because a significant number of farms are under contract with FSA or NRCS for the whole farm property. You can't just take a part of it out of a 20 or 30-year contract, you know, lease it to another LLC, et cetera. And the other main question I had was the thing about mortgages. And I'm curious for you all, the CCB, has this come up? Because we haven't heard about this, and I can imagine, actually I know many people operating who do not outright own their properties and are not, is VSECU the only bank? Like, I don't know if their mortgages are being held by VSECU or if VSECU cares or if other banks are holding them. I'm just curious if it's come up.
I don't know if they're talking to their mortgage companies when they get a license.
Have you all talked to banks who hold mortgages to see if this is true? Like, could they forfeit on mortgages, or is this, do you not know any more about this?
I think it would be a case-by-case policy decision at the bank.
Yeah.
Yeah.
It would depend. It would depend on your lender and if you got federal funds for like a down payment.
But I think the point was by Ben was that most they're selling their to like Fannie Mae and Freddie Mac, you know, they're selling those mortgages onto a broader federal market system, right? And I don't understand it all, but
so I do want to clarify a little bit. Essentially, we exist in a funny situation when it comes to banking. And by the way, I have another hour-long presentation with slides ready to go on this. But when it comes to banking, essentially. Department of Treasury and its Financial Crimes Enforcement Network, I think I missed a letter in FinCEN, have released guidance that essentially says banks are absolutely welcome to interact with the regulated industry, as long as they follow a number of specific steps, notably filing what we call suspicious activity reports. And those reports become kind of pro forma in the cannabis industry. Yup, they showed up, they did this much business. We know they're still licensed. Thank you for your time. And so it's not that it's automatically impermissible, but as you've identified, yeah, there can be issues when you have federally backed mortgages and market operators may be out of compliance. To the extent that becomes an issue for the control board, or the legislature rather than a private issue between a borrower and their lender is sort of a separate policy conversation about what the relative benefits are or not. Typically, what we see is in a circumstance where a lender discovers that a borrower is engaged in some violation of federal law, whether it's cannabis cultivation or whatever, there's then the conversation that happens, which is essentially, okay, well, are we going to immediately accelerate your loan and seek to foreclose, or are we going to negotiate out some other option or give you some time to find private financing or similar? And so, in my personal opinion, I think it makes more sense for that to be properly cited within civil law, with the understanding that the control board has protections in place such that if somebody's property is suddenly foreclosed upon and they have to go out of business, we know what that's going to look like, in the same way that any company, that any cannabis cultivator that goes out of business is going to be interacting with the control board on that.
I don't see any other questions at this point, but if you want to keep going.
Sure. Yeah, just a couple more slides. I know one of the conversations and part of Act 166 specifically says a municipality may adopt a bylaw that identifies cannabis cultivation districts. And then sort of the question that I understand was posed to y'all was sort of like, what should those look like, and how prescriptive are we going to be, and what should or shouldn't we consider in doing that? I do not have like 9 other slides that are like, here's how you fix it. I do have 2 more because I think there is some existing guidance that may prove helpful. In addition to that overarching mandate, is this going to be good for small farmers? Is this going to be good for conversion from the illicit market? You have guidance as to municipal land use planning more generally, and my appreciation, I think Mr. Belanger can speak more adroitly to this, is that the plans that municipalities come up with have to demonstrate working towards some, or at least not against, many of these goals. There are a lot of them. This is a long document. And there are other parts that I think could certainly be relevant. There is discussion of traffic congestion, which I know was mentioned, and some other stuff. But the 3 pieces that I think are kind of most instructive on this are that we do have specific guidance that says develop strategies to preserve the long-term viability of agricultural and forest land. And I'd remind you that in thinking about the regulation here, we're still just talking about growing plants. So same growing conditions, same kind of land, same kind of circumstances. And if we're looking at saying, okay, well, is long-term viability something we want to prioritize? That's something to be aware of. And it's not for the legislature or the control board necessarily to say, this is what that looks like, as much as to say these are goals specific to cannabis cultivation, or this is how we're going to analogize to other forms of crop production. So similarly, encouraging agricultural and forest cultivation in all its forms, prioritizing local first in good agricultural management practices and the like. A couple other areas of this statute that really stood out to me. We want to maintain and improve air quality, water, wildlife, forest, and other land resources, and we want to be mindful in our energy use, right? So, as previously mentioned, outdoor cultivation is, within the context of cannabis production, by far the best way to do that, and integrating cannabis production with agricultural production as to the required agricultural practices, as the current statute does, kind of harmonizes that in a really nice way to say, okay, yeah, so we're going to look at environmental impact of things that grow rather than their end use. And by the way, this is all spectacularly common. To my knowledge, cannabis is the only crop that has this kind of bifurcated regulation. You can grow yams for the supermarket or as a precursor to testosterone and estrogen, and nobody's saying, oh, okay, well, we're going to decide how to zone based on which cultivar you grow. And that also provides some additional freedom for growers to figure out what makes sense for their market in a given growing season or as part of their overall strategy. And so, in my mind, and this is kind of circling back, this is why I think our existing nuisance protections, and I know this was also something you're tasked with considering, make the most sense as a solution. We're talking about, as I understand it, about 580 total operators. This is not a tremendous population. And then we're talking about the subset of those with whom their host communities might take some issue. As a reminder, when we look at the right to farm statute and the protections that have now been extended to cannabis through Act 166, that they give it sort of a commensurate degree of protection. A rebuttable presumption is just that. It's rebuttable. And so if you got that circumstance where somebody got a sound permit and then Billy Joel shows up, but Billy Joel cranks it up to 12 and plays until 4 a.m, that's still a nuisance. It's and we have the space to make that differentiation. All we're saying is the fact that you are cultivating and the activities that are typical to farming are not automatically going to be construed as nuisance. And so we do have to meet these 4 elements, right? It has to be in conformity with the applicable law, and the cannabis statute specifically clarifies the fact of federal prohibition doesn't change that, and similarly, which wraps are going to apply. We need to be consistent with good agricultural practices, and we're going to look at the timing and the scale of operations and how they may have changed. And with that, we see that that it's explicit how we can rebut, right? When it has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference. And of course, that our agencies, whether it's the Department of Health or DEQ or whomever, can continue to enforce. So where does that leave us? I think, in my personal opinion, these siting requirements present a real risk to small farmers and small cannabis cultivators. I think there's a real possibility that they're going to increase expense for those constituencies, and that maybe the best case scenario is that they may create some opportunities for better resource players to either enter or transition their operations in the market. That's not necessarily to say, well, the legislature shouldn't give municipalities the opportunity to take that risk. I think that's entirely within the board's right to recommend, and I think it's within the state's right to enact. It's my personal thinking, and that's based on quite a lot of looking at what's happened in other markets, that it's unlikely to prioritize the interests of small operators, and we haven't seen good examples of ways in which that has happened, unless it's accompanied by substantial amounts of tax or grant support. I do think that cannabis and hemp in particular, we should be thinking quite closely about how we are harmonizing our approaches on that, recognizing the very real possibility that a lot of what's currently hemp will be cannabis as soon as next year. And then a lot of what's cannabis may be agriculture within a unpredictable but presumably very short period of time. If you ask folks what the motivation is for rescheduling, on paper, there's a lot of conversation about the interests of small farmers. There's a lot of conversation about whether the government should be involved in having more FDA involvement. But most of what it comes down to from a lobbying perspective is 280E and the tax benefit. And there are a whole lot of very well-resourced entities that are pushing really hard to get those tax breaks. So there's a lot of pressure on in a completely bipartisan context. My personal feeling is that nuisance laws do what the zoning regulations would be trying to do. If you have an issue with a specific farm in a specific town, we already have rules on the books that say there's a rebuttable presumption. Let's go ahead and rebut. Does it rise to the level of objectively offensive or harmful behavior such that this particular operation needs to mitigate or shut down? And, above all, and I think this really echoes Mr. Boulanger's point, we need greater clarity across the board in terms of how any of these rules will be enforced. So at present, our nuisance standards don't say, well, this is what is objectively nuisance. In Vermont, we say it's up to the relevant agency or relevant municipality to determine their own standards for that. And we see nationally, a lot of folks a lot of courts have used language around prevailing community standards and the like. There are spaces where other states have taken some approaches to try to bring a little bit more objectivity to that, whether that's mimicking air quality nuisance rules about how many parts per million when you're a certain distance from the site. We've seen some that have just said these behaviors are objectively not nuisance, or if you're in comportment with the license, it's not nuisance. And we've seen other versions of this as well, where in Vermont, for example, we don't have a very specific ag nuisance definition, but we do have a statute that says animal illness is nuisance as a matter of law, such that the government can step in and take steps to address it. I think, in preparing all this, the statute I found that I had the approach I most liked was one I didn't know existed: falconry. If you want to have a hawk in Vermont, you need a permit. To get the permit, you go ahead and ask for the permit and they give it to you, and you're allowed to have it as long as your falcon doesn't become a nuisance. And to me, that makes sense. When we're talking about the number of operators we have, when we're talking about the size of operators, it also provides a little bit of a hook to say to licensees, it's on you to make sure that you're not going to become a nuisance, rather than saying, as long as you're located 30 miles out of town, you can do whatever you want. That's what I have for y'all. Happy to chat more about this, certainly in the next 10 minutes, but also really for as long as you all want to talk.
Well, we do have
just
Samantha, can you
go
hold on one
back?
second? So can you hold on
Yeah.
one second, Samantha? Just want to give a time check because we do have one more person to hear from. We have about 10 minutes left.
Oh, I'm so sorry. I had no idea.
Oh, no. This was great. And we needed, this is probably the most relevant conversation we've had on this question that we are tasked with figuring out, which is very challenging. My only question, this is reiterating your disclaimer, not legal advice. Do you have any thoughts on how a court might deal with the rebuttable presumption, kind of prong A, which is about conformity with federal law?
Yeah. So if you look at Act 166, it punts that a little bit. Essentially, what it says is we're going to treat cannabis operators as if they're agricultural operators, as long as they're in conformity with our cannabis statute. And then our cannabis statute says to maintain a license, you have to be in conformity with all federal, state, and municipal law, except as otherwise specified. And so I think the interpretation there is that this would fall within otherwise specified.
Okay. Thank you. Samantha, did you have a quick question?
Yeah, just that I agree this is really helpful and relevant, and especially the last two slides. And I just want to see slide 19 again so I can finish reading it.
Sure.
We'll post it on our website if you're
yeah,
all right
I'll
with
send
that,
over
Ben.
a copy, as well as I've got I don't know that I'd call it a report, but I've got a little memo that also provides more of the sources and background.
That's great. This is really helpful, very useful, really dense material. So thank you for putting it together for us. And
For sure.
I'm sure we'll be in touch if there's any additional questions.
Wonderful.
Thank you so much.
Happy to chat. Thanks, everybody.
Yeah. Sam, I saw you join. Sam sent the board a proposal regarding advertising, which is the second prong of our kind of task here. And, just given that we're kind of closing in on the holidays and everything, I want people to have time to consider what that proposal is. I think so far it's the only one that we've received. Sam, are you still with us? Would you be willing to kind of walk through that? I can pull it up on my laptop if that's helpful.
Yeah, sure. If you want to present it, and then I can just give a quick run through. I know we're getting towards the end of the meeting, so I'll keep it brief.
Sam, one of the things that we're required to do is assess the impact of the changes to advertising laws. And so I think what might be useful context is for you to discuss the impacts of the existing advertising laws on your business. maybe, what we've heard a lot over the years is the kind of disparity between cannabis advertising laws and intoxicating hemp-derived products, as well as kind of just the illicit market and the kind of lack of advertising laws there or lack of enforcement of them, and then also just kind of the disparities with other regulated substances like pharmaceuticals or alcohol. But
Sure.
I'll pull up your while you respond to that, I'll pull up your proposal.
Yeah, so I think, and again, my name's Sam Bellavance, owner of Sunset Lake Cannabis and Lake Effect Vermont in South Hero. I think our challenges, you could break them down into three segments. One, and the first being part of having a regulated, licensed market was the ability to bring people out of, the illicit use market. Our ability to do that is hampered by not being able to more, easily address the community at large and let them know, hey, products that you may have been purchasing elsewhere, you can now get these, at a Vermont dispensary. They're safe, they're tested. So that kind of direct to consumer communication is very difficult. Furthermore, and this is something I'm very aware of, given our location in South Hero, we're right across the lake from New York. We have New York cannabis dispensaries actively advertising in Vermont, spending lots and lots of money to basically draw Vermonters across the ferry into New York to advertise at those dispensaries. And this is something I would love to, if we want to do a follow up on this, bring on maybe a retailer who's located in southern Vermont, because I think we have a similar issue with Massachusetts, where they're basically able to advertise in our state and draw consumers away. So the same amount of cannabis is being consumed. It's just whether or not it's being consumed, from Vermont growers and Vermont retailers, or New York growers and New York retailers, or Massachusetts growers and Massachusetts retailers. New Hampshire, I don't think is an issue at the moment, but it kind of brings in, and this was something I was thinking about in the previous presentation, as we move towards a future of more and more states legalizing, potential federal legalization, having maybe not the exact parity, but closer parity between neighboring jurisdictions, I think would put Vermont farmers and Vermont licensees in a much better position. So to get to these specific proposals here, this was, to be frank, my very, conservative small ask proposal. This is not removing all advertising restrictions. This is not, doing anything that would even put us on par, with alcohol, or even with like online hemp sales. This is something that I think is, small enough changes that it should get legislative support. But there are also changes that could be substantive and just help create some market clarity. So do you want me to go through these now?
Sorry. So everything that's not highlighted is existing law, correct?
Correct. Yep.
Okay. So then what we have is a definition of advertising itself. Once that's the threshold question always for the board. If something's not advertising, if it's not one of these things, then we don't have to review it. It's not subject to any of the further restrictions that are kind of further below. But this is the kind of definition of advertising, and then it has these exclusions. And so the first instance of amendment would be to add to that list of exclusions as what does not count as advertising.
Exactly. And this is something, and I'd love to get the board's thoughts, and I don't know if there's anyone from compliance on this call today, but just signs that are located within the dispensary. If something where someone's already been ID'd, they've entered the dispensary, they're standing at the counter, and let's say there's a little placard that says 20% off, Forbin Finest, joints. Do we want to consider that an advertisement if it's something that's already located inside of a cannabis establishment? I think that would be something that I don't think it's a great use of board resources to be reviewing those. And I don't think that is something where, by its very nature, it's not appealing to a broader youth audience because it's physically located inside of a establishment where people are being carded upon entry. And the next one would be text or email messages to age verified customers. So most dispensaries, including my own, you have the option, when people are checking out to collect their email or their phone. So again, these are people who have been carded and already made a cannabis purchase. So enabling the ability for us to follow up with them with a newsletter, with sales, with, just here's a new product we got at the store. That kind of continued communication is very critical to, maintaining a customer base. And I just don't know logistically how that, if we wanted to say, hey, emails to your existing customer base are advertisements, I'm not sure how that would be reviewed in a way that would be efficient. So again, those two are basically saying things when we're communicating with people who are already in a retail store or making retail purchases, they've already been ID'd. They've already, they've passed through enough gateways where we're, confirming that they're not under 21.
All right. And then so this second part is once something is determined to be an advertisement, then it has to follow these restrictions or be compliant with these. So do you want to just talk about the next part of your proposal?
Yeah, sure. I think with the free samples of cannabis or cannabis products, I do understand that there are some tax concerns there, and I believe that's part of the reasoning behind that. I think that's something where it could either be repealed or clarified, because then you get into situations where, if it's a buy one, get one, is that a free sample? If it's something, we had stores saying, oh, you buy this, you get a joint for a penny, but then we heard from compliance that that's not allowed. So then the question is, when is free? If a penny is considered free, what about 50 cents? What about $1? What about $2? If something's sold for 99% off, is that free? So I think there's something where I would either want that to be repealed, or if that needs to be maintained, for tax purposes, it could certainly be clarified in terms of what we mean there. And then
Can I
lastly,
just ask a quick question?
Sure.
Can I ask a quick
Sure.
question, Sam, on that? So, within your POS system, would it be easy for you to keep track of something that is sold and something that is given as a free sample to make sure that someone doesn't go over the possession limit?
Yep. Yeah, you
Okay.
could. You would just basically offer it at 100% discount. So it would still be tracked in terms of inventory. It would just be more for pricing. And again, that of this section, it's probably the one that I'm least passionate about. I just think there could be some clarity there, because we just need to know exactly what constitutes free is something that I've heard different answers on, and I would love to just get that clarified. But
Yeah,
great
that's
question.
great.
Yeah,
Yeah.
we want to track that inventory.
When it comes to those types of questions, we can get more clarity. We usually just ask the tax department for what they feel like complies with their tax collection requirements. But yeah, I think as we are assessing the impact of what this proposal might mean, I think what we're going to do is look internally. Does this change our processes? Does it change our processes in a way that requires additional resources, less resources, et cetera? But we will also just make sure the tax department takes a look at this to assess any impact to them.
Awesome. That's great. And then my last section here, and this is something that I feel passionately about, and just being in Montpelier last year, talking to a lot of legislators, it feels very, common sense doable that, if you're in a bar or a distillery seeing a cannabis advertisement, I would say would be appropriate in that context. And it's something where we have tried to work with local breweries, and a lot of them, they don't have that 15% data. They're not tracking it. They say, hey, we're a bar, we card people when they come in. But sometimes someone might come in with their 19-year-old child, and they might hang out at the bar with them, but so the data is not there. But I think for me, this section is just let's take 2 steps back and think about, what is this statute really trying to prevent? It's trying to prevent marketing to youths and children. And I would say, in the context of being physically inside of a bar or inside of a distillery or a tap room, is that really where we're concerned about youth advertising? And I think it's good for cannabis producers, because first off, there's a lot of breweries in Vermont. That's one of the things we're known for. So it creates a lot of really great opportunities for advertising in a context where the impact of children or youth seeing the advertising is minimized. So, and I would love to hear your thoughts on that section as well. That's something I have thought of, and it's been fairly anecdotal, but I would love to get the board's thoughts on that as well.
We're really only evaluating these for impact on our processes. I would leave it to Jill and the kind of public health folks to respond to this from how they see this impacting kind of, public health outcomes. And Jill, you don't have to do it today. I know that you didn't have any advance notice of this proposal. So, but I wanted to just get it on the record today so that you'd have some time to think about a response, or kind of vet it through your executive committee or whatever else. But do you have something you want to respond right now, Jill?
Yeah, I guess I just want clarity, because the way this proposed language is written, and hi Sam, I'm Jill Sudhoff-Garian, and I represent the Vermont Medical Society here today. And it looks like you could advertise anywhere that alcohol is sold, not just where it's served. And so that includes every grocery store, every convenience store in Vermont. There's just alcohol is very readily available in places that families and youth frequent often. So just wanted a little bit of clarity on that, and if there's a way for you to just talk about your thinking there. Thank you.
Awesome. That's great. I think that's a great question, and something, again, this is my initial proposal. I'm more than happy to get feedback and kind of hone it in a way. I guess my intent there is not that we'll have cannabis ads all over Hannaford's or Shaw's. So that is a very good point, and I appreciate that. I think for me, the served is the more of the strong point than sold. So maybe we could hone that in a little bit, the language. But I'm thinking more of, places where people are actively consuming alcohol that tend to be, they probably meet that 15% threshold. They're just not collecting that data, because why would they if they don't have to? So if we wanted to kind of hone in that language in a way, that would make it okay. We're thinking of breweries. We're not thinking of grocery stores. That's something I would certainly be amenable to.
Thank you. I'll have to take this back to VMS and probably comment on it.
Yeah, and Jill, we have until, I think Julie mentioned, the report's not, or I mentioned, it's not due until January 15th at this point. So I know this is, we're closing in on the holidays and everything else, but I think we'll have a little bit of extra time for VMS to consider this.
And I think there is some middle ground to it where we think about like specific liquor stores where is that the same as a supermarket? Is that, and we can kind of have those conversations, and I'm happy to engage on that. But I'm thinking of just basically identifying places where there is, a reasonable presumption that this would not be a youth targeted location.
Yeah, makes sense.
That
Okay,
makes sense.
great.
Yeah, thank you.
So we have a meeting on this next week. If there's any other proposals around advertising that anyone here would like us to consider, again, our assessment will most likely be limited to the kind of practicality of implementation, not the kind of, potential public health outcomes of changing the advertising laws. So Jill, I'd really hope to just lean on the medical society for those types. And, you can certainly branch out beyond that if you want to bring in kind of the prevention folks as well. But anyway, I really appreciate it, Sam. I know you had something come up earlier, so thanks for joining us. Thanks for kind of getting this on the table so we can all consider it. Next on the agenda is general discussion. Is there anything else we need to cover? We have another meeting next week.
Yep, on Tuesday, I think, the 17th, whatever day of the week that is. I think it's Tuesday.
Yes.
Okay. And so between now and then, I will start drafting something for us to look at together in that meeting. And then we'll have some time after that for folks to kind of digest it, to consider it, and give feedback before it's submitted in January.
Great. Any questions for anyone about process or substance?
I guess this is Graham. My question about the next meeting is, will the next meeting be less presentation? Like we're all going to be discussing what you draft and different people's perspectives.
I'll the presentation would just be me sharing it with you, but yes, more discussion. Yep.
I guess the only thing I'm thinking is that, there's a number of us organizations named in this working group, specifically around outdoor setting. Like I think some of us have very clear positions that you can see in legislative record, or I'm happy to pass along to you, but some of us don't. I'm really curious in particular about the League of Cities and Towns, if you all have position statements, rationales, processes you go through internally to determine these things that you could send along to other members of the working group if that's possible.
Yeah, they're all available and posted on VLCT's website, which is vlct.org. If you go to the advocacy tab, you can find the 2025-2026 municipal policies, which were approved by all members of the organization at the October meeting. We represent 247 municipal governments along with a number of villages. And we also just released the 2025 session priorities for this legislative session. And you can also find a description of the organizational practices that lead to the development and approval of those policies, which is a committee process.
Great.
Thank you.
Jeffrey, I see your hand raised.
Oh, sorry, I'll say one other thing.
Oh,
There's also
yeah, sure.
There's a wealth of information on the website about the other services and programs that we provide municipal government members, which includes insurance, confidential legal advice, a number of training resources for employees and elected leaders of municipal government, all sorts of services that help governments function well in addition to advocacy.
Jeffrey, did you have a question or a comment?
Yeah, if I can make a brief comment as we close out here.
Sure.
Can everyone hear me okay?
Mhm.
Terrific. Yeah, just turning back to, I guess for the record, Jeffrey Pizzatello, Vermont Growers Association, one of the named parties here under the coalition, the Vermont Cannabis Equity Coalition, along with Rural Vermont, NOFA Vermont, Vermont Racial Justice Alliance, Green Mountain Patients Alliance, and others. Just I want to extend appreciation to Matt and Ben for your presentations today with regards to outdoor siting. I just want to briefly, reflect on what I heard today. It sounds to us that, towns prefer that this situation be as simple as possible. And I think that's a sentiment that we hear within the industry as well. And all of the notable points that Ben had pointed out with regards to, really the benefits of the ag policy that really started back in 2022, right? We're talking about Act 158 that later got amended during, the subsequent sessions with Act 65. That brought when you speak to other states, everybody's want to put this on the record, as I do time and time again. It created a gold standard. There are not many things that are right in these adult use markets. Vermont really raised the bar when it came to outdoor siting, outdoor cultivation, equitability, accessibility. Other states aspire to arrive at similar ag policy as we have here. So I just want to thank everybody for that. I want to get that on the record. We look forward to the ongoing conversation next week, and and we hope to see, as the industry largely hopes to see, that these cultivation districts and these setbacks get reassessed next legislative session. Thanks so much.
Thank you. Anything else?
Nope.
No. Okay. Well, we'll see you all next week. Thank you for joining today.